Good afternoon, Mr. Roland. My name is Shilifia Kefas Katongo, and I'm your legal advisor today. I'm dedicated to understanding your unique legal needs and providing you with personalized solutions. I will provide you with a clear and concise video presentation today that explains the relevant legal aspects and potential outcomes with your situation. So, Mr. Roland, the first thing we need to establish are the rules of a written agreement. Certainly, let's break down how a written agreement becomes a contract in a simple way. You and Ricky made a deal to allow him to use your premises for his motorcycle business. That written document, which you signed, even though not formalized, was your written agreement. Now, this written agreement turned into a legally binding contract when a few things happened. Offer and acceptance. You made a clear offer and it was accepted. You both agreed on the same terms. Consideration. This took place when you accepted the 5-month payment that Ricky gave to you. Legal capacity. Both of you are capable of making decisions and aren't being forced to do it. You're both adults of sound mind. Mutual agreement means you both meant the terms of the written agreement and it was done. This is shown by the fact that you both agreed to the terms and conditions of the agreement. Once you've got all these things in place and you both sign the document, it becomes a contract. This means you are both legally obligated to follow the terms you wrote down. If someone doesn't do what they promised, this is considered a breach of contract. So that's how a simple written agreement can become a full-fledged contract. It's like a promise that the law can help you keep. So to begin with, I will go through your situation once again. Ricky entered into an agreement with you to lease your workshop for his motorcycle repair business. The lease was set to start on 1st March 2023, and the agreement stated the rent should be paid a year in advance. However, Ricky could only pay the equivalent of 5 months due to unexpected medical expenses. Since August 1st, Ricky has not paid any further rent, claiming that the informal agreement is not legally binding. Now, let's discuss the legal aspects of the situation. So, Mr. Roland, the first thing we need to establish is what kind of lease it was. A lease gives you the right to occupy someone's land for a determinate amount of time. There are 2 types of leases, namely a legal lease and an equitable lease. The Land Registration Act of 2002 defines 2 categories of legal leases. Under Section 52, subsection 1, legal leases more than 3 years are created by a deed which is signed, witnessed, and delivered. Under Section 54, subsection 2, legal leases less than 3 years can be created by simple oral or written agreement. However, it must take effect in possession and mostly rent. As for an equitable lease, these are leases which have not satisfied the formalities of a legal lease and are mostly referred to as informal leases. It may be enforceable and is recognized by a court of equity. These types of leases can be seen in a very similar case of Walsh and Lonsdale. Certainly, let us break down this case to understand equitable leases in simpler terms. Let's say you decide to rent a property for a period longer than 3 years, but you don't follow all the standard procedures for drafting a legal lease. The parties in Walsh and Lonsdale were in the same circumstance. They lacked a legal lease. The crucial point is that they both obviously meant to establish a lease. Therefore, the court decided to accept it as an equitable one, even though certain formalities had not been fulfilled. This indicates that the tenant retained some rights and protections as if they had a standard lease, even though all the formalities weren't completed. Okay, so as you can see, the 4 issues I've prepared in these slides. I've explained already the type of lease, which was seen in the case of Walsh and Lonsdale. Now, let us find the issues in this certain situation. The first issue here is for us to figure out whether the lease between you and Ricky is legal or equitable. Has he satisfied the elements of a legal lease? The first element of a legal lease is exclusive possession. Considering that Ricky has been using the property exclusively for his motorcycle repair business, which indicates that he is in charge and occupying it, he does have this component covered. The second element that has to be satisfied is a determinate period. A legal lease must specify the exact end date. However, in Ricky's instance, there isn't a precise end date specified in the lease agreement. It is unclear and imprecise. This is an issue because the lease needs to have a precise and transparent duration in relation to legal principles. The maximum length of the lease must normally be known from the outset in order to comply with legal requirements. Due to this, Ricky has not satisfied this element. A case similar to this situation is Prudential Assurance Company Limited and London Residuary Body, where the court determined unanimously that no binding lease had been created because the tenancy was too ambiguous and uncertain to be effective. In another case, Lace and Chandler, a tenancy failed because there was no certainty about the maximum duration. The last requirement is rent or consideration. Yes, this element has been satisfied, but this is not a strict requirement. The court is going to view the lease between you and Ricky most likely to be an equitable lease. So, Mr. Rowland, due to consideration being satisfied by paying the 5 months rent, which was accepted, and Ricky being occupying the premises, the agreement was written and signed by both parties but never formalized. Another issue you may face, Roland, is that Ricky will bring up the defense of the protection of the equitable lease under Schedule 3, Paragraph 2, which states the interests of persons in actual occupation. Also, it is possible that a purchaser of land may not be bound by an existing equitable lease according to the rules of registered and unregistered conveyancing. The problem is likely to be more acute in unregistered land. So if your land is unregistered, that will be another issue you may face. In conclusion, Mr. Rowland, looking at your situation, the courts may order the most likely remedy in this situation, which is specific performance. The doctrine of specific performance is a legal concept that means when one party fails to fulfill obligations in a contract, a court can order them to perform their promised actions exactly as specified in the contract. In this case, the court can make Ricky, the breaching party, do what he required to do in the beginning, which is pay a whole year of rent in advance. This is to ensure that you, sir, receive what was promised in the contract. Mr. Rowland, thank you for reaching out to me, and I really hope that I managed to satisfy your needs for a legal advisor. Have a great day.